Well, let's say that the state is under clear notice. Is the guard also privy to that clear notice?
So, Justice Thomas, we don't think clear notice is required under the purpose of the spending clause because we care about the notice of the recipient, but I think the officers here clearly had notice, and I do think that qualified immunity...
Okay, so how did they get that notice, and what was the notice?
Well, I think the statute clearly applies to them. If you look at, Petitioner's Counsel emphasized the text of the cause of action, it applies to a government defined as an official.
So do you think they were aware of the state's commitment to the statutory requirements?
I think that we're all sort of held liable for what's in the United States Code, and I think that this isn't surprising to state officials. So you think you have clear notice of everything that's in the United States Code? Well, Your Honor, I think that the officers here clearly had notice. Officers are used to facing 1983 liability and are liable for violation of all constitutional provisions. They know that certain requirements apply to them when they accept employment in a federally funded prison. And I do think that qualified immunity is an important backstop because they can only actually be held liable if their conduct violated clearly established law. And they concede liability, right? I mean, in other words, they concede that these substantive provisions apply to them. So they must then know, or, their response was not, we didn't have notice that we had to behave this way. Their response is, you can't sue me individually for damages as a result of that. Exactly, Justice Jackson. At page 46 of their brief, respondents admit that they are bound by the substantive condition. I think that makes this a very easy case for purposes of the spending clause issue because they admit they can be sued in their official capacity for an injunction. I think that means, as Petitioner argued in his brief, and I don't take respondents to have disputed, that respondents could be held for contempt, and that can have personal consequences.
I'm sorry, finish your question.
They could be held for contempt, and that could have personal consequences. So I think that the necessary and proper clause, if it means anything, it can mean that Congress can go one half step further and say that we can reach these people in their individual capacities as a necessary and proper means to enforce the substantive condition of RLUIPA.
Well, I think